Welcome to today's Explainer. We are jumping straight into the mechanics of structuring safe, compliant, and highly strategic M&A deals under Vietnam's updated foreign investment laws. We're going to unpack the dense legal theory, sure, but more importantly, we're applying it to a high-stakes, real-world scenario. So let's get ready to master the new rules of the game.
Okay, let's kick things off with a huge mystery that'll frame our entire analysis. Imagine you're a foreign investor. You've got millions ready to drop into a thriving Vietnamese company. Naturally, you want control, right? So you aim for 51% ownership. But what if I told you that a mere 2% difference, just shifting from 49 to 51%, could be the absolute difference between a smooth, profitable acquisition and a total legal nightmare? Why does that tiny percentage completely alter the fate, timeline, and legal risk of a deal? Keep that in the back of your mind as we go.
Here is our roadmap to solve that puzzle today. Number 1, new foreign investment laws. Number 2, the 50% threshold. Number 3, anatomy of an M&A deal. Number 4, the poultry acquisition case. Number 5, 7 critical legal red flags. And finally, number 6, the strategic deal solution.
All right, let's get into Section 1. New foreign investment laws. The 2025 and 2026 landscape. Just look at the sheer volume of recent legislative overhauls. We've got the new Law on Investment 143/2025 taking effect in March 2026, the updated Enterprise Law of 2025, plus brand new implementing decrees like Decree 96 and Decree 168. What does this tell us? Well, right off the bat, it means the old M&A playbooks just don't apply anymore. If you're still relying on frameworks from 2020, you're flying completely blind in today's market. And this brings us to a major global standard of transparency that's officially hitting Vietnam. Decree 168/2025 introduces some incredibly strict rules around what's called a beneficial owner, or BO. Based on the Financial Action Task Force's Recommendation 24, this rule literally forces us to look past the corporate shells to find the ultimate human controllers, basically anyone owning 25% or more, or anyone exercising controlling power. So when you're acquiring shares now, you aren't just looking at the paper company anymore. You are legally required to scrutinize the actual humans pulling the strings behind the scenes. Moving on to Section 2, the 50% threshold, the look-through principle. It really all boils down to this one specific number, 50%. Enshrined in Article 20 of the 2025 Law on Investment, this isn't just a casual benchmark, you guys. It is a hard legal border. It defines exactly how the Vietnamese government is going to treat your investment. Here's exactly how that border works. If a foreign investor holds 50% or less of the charter capital, the target company is generally treated legally as a domestic investor. That means simpler procedures and super fast market access. But the absolute second an investor crosses that 50% line, say to 51%, the target instantly transforms into a foreign invested entity. Boom. That triggers a massive wave of compliance checks, mandatory pre-approvals for the M&A deal, and some really heavy market access restrictions. And as we're about to see, this look-through principle doesn't stop at the target company. It cascades all the way down to every single subsidiary they own. Which brings us to Section 3. Anatomy of an M&A deal, the mechanics. So while the overall process follows a pretty strict chronological path, starting with a letter of intent, moving to the share purchase agreement, and finally closing, it's step 2, where these deals are really made or broken. Legal due diligence. This acts as your ultimate shield. It's not just about understanding the target's business model, it's about actively digging up hidden liabilities way before you ever write that check. Let's put this into practice with Section 4, the poultry acquisition case theory to practice. All right, picture this. A foreign buyer wants 51% control of a massive domestic poultry empire. The parent company processes poultry and is owned by 6 domestic individuals, with our main seller holding a solid 75%. This parent also fully owns 2 subsidiaries, one for packaging and one for distribution. Now remember that look-through principle we just talked about? If the foreign buyer takes 51% of the parent, that parent immediately becomes a foreign invested entity. And because of that, the 2 subsidiaries also instantly become foreign invested entities. The legal status of the entire corporate group literally changes overnight. And that leads to Section 5, 7 critical legal red flags. So the due diligence uncovers some major issues, starting with red flag 1. The target converted to a joint stock company back in December 2020, but they never actually issued a shareholder register or share certificates. Think about that. Legally, the seller can't even formally prove they own the 75% they're trying to sell you. That is a massive fundamental transaction risk. And red flag 2 is just as wild. The distribution subsidiary has this tiny side hustle selling rice. But here's the catch. Rice distribution for foreign entities is heavily restricted under WTO commitments and local laws. If the company turns foreign at 51%, this little unlicensed operation suddenly becomes a massive legal violation.
It doesn't stop there. Let's look at red flags 3 and 4. Internal distribution contracts between the parent and the subsidiary were never actually approved by the board or shareholders, which makes them legally voidable. And then there's the bank debt. The subsidiary has a loan that requires them to notify the bank before any restructuring. Buying 51% at the parent level constitutes a change of control. So, failing to notify the bank, that could accidentally trigger a massive default down at the subsidiary level. Moving on to red flags 5 and 6. We've got missing food safety certificates at the retail locations, which is bad. But the fatal flaw here is red flag 6, an absolute environmental time bomb. The main poultry processing factory has been operating illegally without an environmental permit since 2020 under the law on environmental protection. If the buyer takes over now, they are inheriting a ticking time bomb that risks immediate government shutdown and, frankly, massive fines. Finally, red flag 7, which brings us full circle to our opening mystery box. The target company was granted land for a new factory and is right in the middle of processing its land use right certificate. If the buyer acquires 51% right now, the company instantly becomes foreign invested. And land allocation laws for foreign entities are way stricter than for domestic ones. Converting mid-application would force the local government to freeze or entirely restart the pending land use rights process indefinitely. The company's future expansion would be completely paralyzed. So, how do we fix it? That's Section 6. The Strategic Deals Solution, Staged Completion. The answer is a totally brilliant legal maneuver called a staged completion. Instead of just buying 51% right out of the gate, Phase 1 involves purchasing exactly 49%. Because it doesn't cross that magical 50% threshold, the company remains legally domestic. This bypasses the lengthy foreign M&A pre-approvals, lets the pending land use rights process smoothly as a domestic entity, and hey, the seller gets paid early. Then, for Phase 2, the buyer holds a call option for that remaining 2% to ultimately get control. But crucially, they only exercise this option after the seller fixes the environmental permits and secures the land rights. The buyer completely neutralizes the foreign investment risks while still locking in a clear path to control. This matrix effectively breaks down how these fixes get deployed in the share purchase agreement. The really severe issues, like that missing environmental permit, establishing the shareholder register, and pausing the rice distribution, those are drafted as strict conditions precedent, meaning the deal absolutely does not close until the seller fixes them. But minor manageable issues like grabbing some food safety certificates for retail branches, those can be pushed to post-closing covenants, which are basically obligations the seller has to fulfill shortly after the cash changes hands. As we wrap up this explainer, I really want to leave you with a vital challenge. That tiny 2% difference between 49 and 51, it's not just math. It's the entire legal reality of your investment. It literally determines whether you operate freely or face an absolute mountain of restrictions. So when you're looking at your next cross-border deal, you've got to ask yourself, thanks to the rigors of due diligence and strategic deal structuring, are you actually buying a profitable business, or are you just buying someone else's legal liabilities? Stay focused, keep learning, and I'll catch you in the next explainer.